Welcome, everybody. Thanks for joining us. We're going to talk today about the latest developments in patent litigation. And first, I'm just going to introduce us to you. I'm a trial lawyer. I serve as trial counsel in patent litigation. I've tried cases in the Eastern District of Texas and the Northern District of California, and before the ITC. Here with me today is my partner, Katie Lynn. Katie Lynn is also an experienced intellectual property and patent litigator. She's also done copyright cases. She's represented Comcast, Netflix, OpenAI, Zscaler, and others. And I've also got here today with me my colleague, Emily Hasselberg. She represents Google, Netflix, and BOE technology and patent cases. She seconded at Netflix in their patent litigation group, and she just finished a trial in EDTechs in front of Judge Gilstrap. So let me cover what we're going to go through today. We've got three main topics to go through. One is filing trends. Where are people filing and why are they filing there? Then we're going to talk about legislation. As usual, there's a bunch of pending legislation aimed at quote unquote reforming patent law. And then finally, we're going to go through the lightning round where we talk about the latest development, mostly federal circuit developments in patent law.
I will kick it off with patent trends. Thank you, Sharif, for the introduction. This will probably not come as much to a surprise as many of you, but patent litigation was on the rise in 2025. Overall, for the year, the amount of litigation was higher than any of the other three preceding years. And compared to 2024, it was up by about 16%. Amidst this rise in litigation, what became clear is that Texas, and especially the Eastern District of Texas, is the preferred venue for patent plaintiffs. Overall, nearly a third of patent cases in 2025 were filed in the Eastern District of Texas. For cases brought by non-practicing entities, that number you can see on the screen is even higher. Almost half of patent cases filed by non-practicing entities in 2025 were filed in the Eastern District of Texas. And then in the number 2 and 3 spots for other favorite jurisdictions for patent plaintiffs, you see the District of Delaware and the Western District of Texas. Looking at the judge level rather than the court level, you can see here that Judge Gilstrap in the Eastern District has way more cases than any other federal judge. He presides over 19% of the new patent cases that were filed in 2025. I looked up, to put this in context, how many Article 3 district court judges there are across the country. There are 677 active Article 3 district court judges, but one of those judges has almost 1 in 5 the patent cases that were filed in 2025.
Here is the main reason that people are filing in the Eastern District of Texas, and that's Judge Rodney Gilstrap. What I have on this slide are some metrics that show the differences in the types of results you might see in the Eastern District of Texas versus the Western District of Texas versus the District of Delaware versus the Northern District of California. And there's two important things to know as you're looking at this data. Number one, the Eastern District of Texas is all the judges there, not just Judge Gilstrap. And number two, the other thing to know is this is not winning or losing a case. So for example, when it says a finding of no infringement in the Eastern District of Texas, it does not mean that 51% of the time you win a no infringement in the Eastern District of Texas. What these numbers represent is any time any judge in that district has ever ruled for no infringement. So maybe it was one patent in a summary judgment motion. Maybe it was one claim in a claim construction order. So it's just any ruling at all, for no infringement, any ruling at all of invalidity. And what you can see is that by and large, the Eastern District of Texas is much more plaintiff friendly across the board than all the other districts, with maybe some notable exceptions. That's true for a finding of no infringement, with the odd man out in this case being the District of Delaware. I strongly suspect that's a result, and where it is the District of Delaware, of Judge Norica, because Judge Norica is not super fond of pretrial motions. She's quite likely to deny motions for summary judgment. She's quite likely to deny one-on-one motions, and I expect, and I think, and she does that as a matter of course. So I suspect that that's sort of dragging down the average here. Same thing on invalidity. EDTEX is the worst place to be for invalidity. Granting a motion to dismiss, EDTEX and WDTEX are kind of tied if you're a patent defendant as the worst place to be. And then, wow, motions for summary judgment, quite striking the difference between the Eastern District of Texas and the other jurisdictions. You saw on the previous slide that Judge David Counts, has moved up to number 2. And I think the reason is that Judge Counts is single assignment. He's the only judge in Midland, Odessa. And so if you're a patent plaintiff, you can file there and you can sort of guarantee which judge you'll get instead of being on the wheel. So he's now the Western District's most popular judge. He has eclipsed Judge Albright. I think how Judge Counts is actually going to rule on the merits of things is still a little bit TBD. He has a 62% grant rate on contested motions to dismiss. So that makes it suggest that maybe he's not so plaintiff friendly after all. I know from personal experience that he actually, or his magistrate, will grant a meritorious transfer motion. So there's some very early signs that there are reasons to believe that he's not necessarily going to be quite the same as Judge Albright. What I will say, however, though, is that he has adopted Judge Albright's standing order, or most of it, and many of the provisions in that standing order are plaintiff-friendly, and he uses the same magistrate judge, Judge Gilliland, who Judge Albright uses. So I think those are some of the reasons that plaintiffs are choosing to file in front of Judge Counts.
So how did we get here where 2 of the most popular patent venues are in Texas? I think a lot of you are probably familiar with this history, but I'll just go over it briefly. Back in 2015, EDTEX was by far the largest venue for patent cases, and that was because, as it is today still, it had a reputation for moving things along quickly, for plaintiff-friendly procedural practices, and for a high success rate with juries for plaintiffs. Then in 2017, the Supreme Court issued the TC Heartland decision, in which it found that venue for a U.S. company in patent cases is only proper in a district where either the defendant resides, so where it's incorporated, or where it has committed acts of infringement and has a regular and established place of business. And later cases have clarified that a regular and established place of business requires that the defendant have a physical presence in the district and employees conducting business in the district. So just having servers, for example, in a district is not enough. So when Judge Albright was appointed, he saw an opportunity because the Western District of Texas, as opposed to the EDTEX, houses offices for major tech companies. So he literally went on a speaking tour with a presentation about why plaintiffs should file in WDTEX. And unsurprisingly, it was very effective, resulting in a surge of patent filings in WDTEX. And even though there have been some guardrails put around judicial assignment since 2022 in WDTEX, it still remains one of the most popular patent venues, as we've been discussing. And as these stats show, decisions like TC Heartland have clearly not taken the wind out of the sails of EDTEX either. So what are your chances of getting out of these venues if you're sued there? Lately, Judge Albright has been granting motions to transfer at a slightly lower rate than he has in prior years. Specifically, he had a 62% grant rate in 2025, which is actually 2% higher than the national average, but lower than his grant rate from prior years. What's also interesting is that after a slew of decisions where the Federal Circuit repeatedly found that Judge Albright had abused his discretion in denying transfer between 2020 and 2021, the Federal Circuit has not granted mandamus on a motion to transfer out of Judge Albright's court in the last 2 years. Now let's take a look at the same stats for the Eastern District of Texas. Judge Gilstrap has granted motions to transfer at a slightly higher rate in 2024 and 2025 than he has in prior years, but he is still well below the national average. For example, in 2025, he granted 54% of motions to transfer, compared to a 63% national average. And at the Federal Circuit, the story is the same. It has not granted mandamus transferring a case out of Judge Gilstrap's court in the last 2 years. One of the major reasons that EdTex remains a hot venue is shown on the screen. Texas juries give big jury awards. 4 out of the 5 jury verdicts in 2025 were awarded by Texas juries in EdTex. So it's little wonder that plaintiffs keep flocking to that venue.
Now let's talk about another big development from 2025, which is the changes in IPR processes and statistics. You can see here on this slide that IPR filings have plummeted, and I will get to the reasons for that in a moment, but the drop is huge. The first few quarters of 2025 look relatively normal, and then you see Q4 of 2025, it went down drastically by around 40%. The drop in filings in the actual petitions that get filed came on the heels of drastically declining institution rates. From 2022 to the first quarter of 2025, the institution rates, which is the blue here, hovered right around 65 to 70%. That meant for petitioners or potential petitioners that for those few years, there was a very good chance of institution upon filing a petition. You can see in the second quarter of 2025, the institution rate drops by 25%. So the likelihood in the second quarter of 2025 of institution was around 40%. It drops even more. By the third quarter, it's down to 23%. And then when you get to the fourth quarter, on this slide, it indicates 41% institution, which might suggest that it's inching back up. But what this graph does not show is that the number, the 41% institution, is actually skewed by the first portion of that quarter before the USPTO director took over sole control of deciding whether to institute. And since the end of October, when the USPTO director Squires was put solely in charge of deciding whether to institute, the institution rate has been closer to 14. That's 14%. So, a small fraction of what many of us were used to for the past 3 years. The reason for these huge changes in the IPR process are multifold. There have been a number of changes, all curtailing IPRs. The first is the expansion of discretionary denials. Most of you are familiar with the FinTIV factors. These were discretionary factors that the PTAB historically had considered when deciding whether to institute a petition when there was a parallel case in district court. They included things like the expected timing of resolution in the district court as compared to the PTAB, the amount of resources that had already been invested by the court, and so on. Back in 2022, in June of 2022, the USPTO issued a memorandum that curtailed the use of the FinTIV-based discretionary denials. It allowed parties to avoid application of those factors if they made a compelling case for invalidity or if they stipulated not to pursue invalidity grounds in the IPR that in the district court that could have been raised in the IPR. And it was important for petitioners. It allowed petitioners to pursue IPRs and get instituted. So in February of 2025, about a year ago, the USPTO rescinded that memorandum and it put the FinTIF factors back in play. On top of that, the USPTO issued additional guidance saying that even more discretionary factors can weigh in favor of denial. One of those factors is called the settled expectations doctrine, which basically means that the patent has existed for a while. We've seen this new doctrine invoked for patents that were issued around 8 years ago. And if they existed for that long, then the PTAB has denied institution on that basis. On top of these changes around discretionary denial, and I already alluded to this earlier, but the authority for who is reviewing petitions and deciding whether to institute has shifted from panels of administrative patent judges who have historically done it now to being the sole decision of the USPTO Director Squires. This has drastically changed how petition decisions are made, and it has also resulted in a lack of reasoned opinions coming out of the PTAB. Some entities have tried to challenge all of these policy changes over the past year. There have been more than a dozen mandamus petitions that have been filed challenging different things that have happened since June of 2025. The Federal Circuit has denied every single one of those challenges so far, which means that there's no indication that the Federal Circuit is going to do anything to step in and stop the changing landscape for IPRs. There are more changes coming. There is already pending USPTO rules that would make it even harder for petitioners. Under the proposed rule here, the petitioners would have to stipulate at the outset that they will not raise Section 102 or 103 challenges in district court. Because of the 1-year filing deadline, that decision is going to have to be made very early in the case. There's also a policy shift that Director Squires has put out in a memorandum that went out just 2 weeks ago on March 11th. He indicated that there is going to be more consideration of the impact on domestic industry for IPR petitions. Specifically, the director will weigh the extent to which the accused products are made in the US, whether the patent owner's products are domestically manufactured, and whether the petitioner is a small business sued for infringement. So the whole landscape, and instead of being a merits-based process focused on the validity of a patent, IPRs seem to be shifting more towards who's bringing the petition and whether there's other litigation. In the face of these changes to IPRs, what we've seen over the past year is a dramatic shift back towards reexaminations. Reexaminations, as many of you are aware, have historically been slower than IPRs. They present other downsides that once you make the request, you're not involved. It can result in what's called whitewashing the art, where the art gets, a rubber stamp from the PTAB, but reexaminations are not subject to this new expansive discretionary denial framework that exists for IPRs. So what we saw in 2025 is that now more people and entities are pursuing reexaminations instead of IPRs. In the last quarter of 2025, reexamination filings spiked by 119%. So it's going up increasingly.
So next, we're going to cover some legislative developments in the area of patent law, or lack thereof, as you will see in a second. Let's start with the PREVAIL Act. So the purpose of this act is to reform the PTAB by increasing barriers to findings of invalidity. It was originally introduced in the Senate in late July 2023, and then amended in 2024. It has bipartisan support, but has continuously failed to make it through the legislative process. But it was reintroduced in May 2025 and is now awaiting consideration by the Senate Judiciary Committee. Some of the key provisions of the 2025 version of the Prevail Act are shown on the screen. These include that the burden of proof to invalidate issued claims would shift to clear and convincing evidence to align with the standard in federal court, that a for-profit entity would require standing to file an IPR petition. So that would include either actively engaging in or having a bona fide intent to engage in conduct that could result in an infringement claim, the right to bring a DJ action, or having been sued. There's also a single forum provision. So if an IPR is instituted, a petitioner could not file a civil action in district court or before the ITC challenging validity. And a petitioner could only file one IPR per patent. And finally, that PTAB panels must consist of 3 members, none of whom were involved in the decision to institute the IPR. Another act that could impact patent law is called the Restore Patent Rights Act. It was introduced by Senators Chris Coons of Delaware and Tom Cotton of Arkansas in July 2024, with the goal of restoring the presumption of injunctive relief for a finding of infringement. It would do so by creating a rebuttable presumption of a permanent injunction if a court enters a final judgment of infringement. And the bill was just reintroduced in February 2025. And the genesis for this act was a 2006 SCOTUS decision called eBay versus Merck Exchange that established a 4-part test to determine whether a permanent injunction is warranted in infringement cases. And one of the factors considered is whether remedies at law, like monetary damages, are inadequate to compensate for infringement. Senator Coons commented that this decision was wrong-headed and forces patent holders into licensing decisions that they don't want. And while the Restore Act doesn't directly alter the 4 eBay factors, since there would be a rebuttable presumption in favor of an injunction, defendants should obviously expect it would be harder to overcome a request for an injunction by the plaintiff.
The next act we want to discuss is the Patent Eligibility Restoration Act of 2025. The point of this bill is basically to overrule Alice and Mayo, and I'll talk in a little more detail about exactly that means. But we've seen this beast before. It was first introduced in June of 2023, and it was withdrawn in November of 2024. It was reintroduced in May of 2025. And in October, there was a subcommittee hearing. It is sponsored by Senator Tom Tillis, who's going to be retiring soon, Senator Chris Coons, and in the House, Kevin Riley and Representative Scott Peter. So it has bipartisan support in both arms of Congress. There are some new co-sponsors added in June 2025. Blackburn and Hirono decided to co-sponsor it. At the subcommittee hearing, there was testimony in favor of the act and testimony against it. There was more testimony in favor than there was against it. And the testimony in favor first came from the former directors Iancu and Capos, so that's from both administrations. And their argument is that 101 law is hopelessly confused and that PIRA would provide stability. And it was opposed primarily by the National Retail Federation and Richard Blaylock from Pillsbury. And their argument is that it would encourage litigation by patent assertion entities and create unnecessary uncertainty for businesses and life sciences. There was also some support from the life sciences. Tom Tillis is, really trying to get this passed before he retires in January 2027. We'll see. One interesting argument that was made was that this somehow makes us, unless this law is passed, we're somehow less competitive as compared to China, because China is issuing a lot of AI patents. And as you'll see soon, some of those AI patents are getting struck down by the Federal Circuit. So I'm just going to very briefly cover existing 101 law. I'm sure many of you know it, but just so that we can contrast it to what PIRA would do. 101 law is basically governed by a Supreme Court case that came down in 2013 called Alice. And basically, at step one, you determine whether the claimed invention is an abstract idea or a natural phenomena, law of nature. If it is directed to an exception to the 4 statutory patentable categories, then at step 2, you determine whether it contains an inventive concept. Okay? And the Federal Circuit and the Supreme Court have sort of given many examples, types of patents that fail that test. What would PIRA do? PIRA would eliminate all judicially created exceptions to patent eligibility, except there is a saving provision for non-statutory obviousness. So that wouldn't go away, but ineligible subject matter exceptions created by the courts would all evaporate. And then the statute would provide for explicit exceptions, and something would not be, oh, you can go back to the last one, something would not be patent ineligible. That's slide 26, yeah, unless it fell within an explicit exception. So one explicit exception is a mathematical formula. Another explicit exception is a mental process performed solely in the mind. Another explicit exception is an unmodified gene. Another explicit exception is an unmodified natural material. And then the other exception is for basically business or other similar social types of processes. Important to note that for the mathematical exception and for the business process, if a computer or software is necessary to perform the mathematical formula or the business process, then actually under PIRA, it would be patentable. It would be patentable, okay? The senators made what I think are some cosmetic changes to try to make it more palatable. Previously, for example, an isolated gene was considered to be patent eligible, and now they've said, okay, isolated is not enough. That would still be patent ineligible. There's some other very minor tweaks that they made to the statute, but basically what it does is overrule Alice and take 101 law to where it existed before Alice.
Great. So we will go over some of the other developments that we've seen over the past year, of which there are many. I know AI is top of mind for so many of us, and there's a few updates that impact patents. So at the beginning of the year, in January, when there was a flurry of executive orders, Executive Order 14179 was issued. This rescinded the executive order that President Biden had issued that imposed certain safety requirements on AI development, and it encouraged faster AI development in the United States. There was then a lot of questions over what this meant for patents and whether it signaled something that would provide more leeway for people relying on AI to develop patents. In November of 2025, if you can just go back for a second. In November of 2025, the USPTO then issued inventorship guidance for AI-assisted inventions. This guidance made clear that only human contributors can be identified as the inventors. But AI tools are permissible to use in development. They're treated generally the same as lab equipment or software or databases. So to properly qualify for a patent, an inventor can use an AI tool to assist in the creation, but the AI tool cannot conceive of the invention. The conception itself still must come from a human to qualify for a patent.
Recentive is a Federal Circuit case that I alluded to earlier in Recentive Analytics versus Fox Corp. The Federal Circuit upheld the invalidation of patents that were directed to artificial intelligence. And what these patents basically claimed was using machine learning to generate network maps and schedules for television broadcasts and live events. And the way the claims were written is they basically had, you feed the model data, and then you train the model, and then you give it some parameters, and then the model would output these network maps and schedules. And the Federal Circuit said, that's patent ineligible. First, they said, well, you're not claiming that you invented machine learning, so that's not what's at issue here. Instead, you're just applying generic machine learning technology to a particular field. And what I thought was interesting is that the court found that the requirements that the model be iteratively trained and dynamically adjusted, those things were just conventional because those were, incident to the very nature of machine learning itself. I think this case shows that AI patents are not exempt from 101 and that they can be and will be struck down if they're claimed at a very high level of generality. Just another interesting note, at the very end of the case, the court also affirmed denial of leave to amend. And the reason the court affirmed denial of leave to amend was that the plaintiff had not proposed amendments that would have saved the patent. And that's, I think, a bit of a shift. Before, the Federal Circuit law was perceived as, well, you need to give people a few chances. And so you allow them amend and allow them to amend, even though reading the patent, nothing was going to change in the patent itself. But I think that's changing a little bit, and you can certainly see that change being cited in cases in the Northern District of California. I won't linger too long on this case, the trustees of Columbia University versus Gen Digital Inc. I think what this case is, this is another 101 case, and it's a case that basically says methods for protecting computer systems from viruses and other malicious activities, specifically methods of emulating a program and comparing its function against a combined model to flag anomalous behavior, that's invalid. And what I think is most interesting is that the court's ruling was heavily based on this notion that you're talking about features in the specification. And those features are not actually claimed in the limitations. And if they're not claimed in the limitations, we're not going to focus on them. There is some older Federal Circuit case law for this principle, but it's sort of been rejuvenated in this case. So if that's an issue in one of your cases, this is a good one for a notice of supplemental authority. It just came down on March 11th, 2026. Okay, this next case, I think, did sort of break new ground in 101 law. And this case is RegenX Bio versus Sarepta Therapeutics. And what it basically held is splicing two existing genes together is patent eligible. Okay, and so what this case was looking at was genetically engineered host cells containing adeno-associated virus sequences with utility for gene therapy. Okay, what does that basically mean? Basically, these scientists were taking a virus and they were taking the capsid off of the virus and they were putting in some bits of gene that were therapeutic, and then they would use the capsid to infect human cells in a good way, right? To introduce this new gene therapy. And there's no question that the capsid the bits of the genes in the capsid existed in nature, and the bits of the gene inside of the capsid, existed in nature. And so it was taking these two pre-existing bits and putting them together. And the Federal Circuit said, yeah, that is patent eligible. The reason that that's patent eligible is that this combination was not naturally occurring, and putting these two things together does something quite different, than how they existed when they weren't together. And they sort of chastised the district court. It was the District of Delaware who got reversed for looking at each of these components in isolation. So I think it sort of does establish a clear rule that, genes, just isolating a gene, that's not going to be patent eligible, but, splicing or recombinant technologies, that is going to be patent eligible.
So this next case relates to a development in Section 112A written description law in the biotech field. So the patent at issue in this case claimed a drug formula for a cancer treatment that included a peptide unit limited to 2 types of amino acids, and that resulted in claiming 81 different possible combinations for the peptide unit. The patent claimed priority from an earlier 2004 patent application. That earlier application disclosed over 47 million different combinations for the claimed peptide unit. At trial in EDTex, the accused drug would only be found to infringe if the patent was entitled to the priority date of the 2004 patent application. So an EDTex jury found that the patent claims were not invalid for lack of written description. They awarded damages for infringement. The defendant moved for judgment as a matter of law on the written description and enablement issues, and Judge Gilstrap denied the JMAL. The Federal Circuit reversed. It found that there was not sufficient written description for the later claims in the 2004 patent application under Section 112A, so the claims couldn't benefit from that earlier application priority date. Specifically, it found that the earlier application's disclosure of a broad genus was inadequate to satisfy the written description requirement for claims directed to a particular subgenus contained therein. And what's interesting is the ratio of what was disclosed in the earlier patent application, so like 47 million different possibilities, compared to what was actually claimed, which was only 8 possible combinations, seem to play a large role in this written description decision. This next case relates to means plus function claims under Section 112F. So brief background, typically when the structure disclosed for a means plus function claim is a computer or microprocessor programmed to carry out an algorithm, the claims are limited by the disclosed algorithm. So to avoid a finding of indefiniteness, a computer implemented means plus function claim must have a corresponding algorithm disclosed in the specification. So in this case, the district court found that the means plus function claim was indefinite because the corresponding structure was a, quote, head controller, which it found to be a general purpose computer, but that the specification didn't disclose a corresponding algorithm for that computer to perform. Notably, the district court had excluded a candidate structure, so an embodiment in the specification, because it didn't perform a function that was mentioned in the specification, but not actually claimed. The Federal Circuit reversed this decision. It found that the district court had overlooked a simpler corresponding structure in the specification, which was actually logic circuitry, so not a microprocessor. And therefore, the patent didn't need to disclose an algorithm to avoid a finding of indefiniteness. This case doesn't actually change any existing law, but it is interesting because it confirms that a means plus function claim is definite if at least one disclosed embodiment provides a corresponding structure. And the upshot of that is that if any embodiment avoids the algorithm requirement for computer and microprocessor claims, the claim can likely survive an indefiniteness challenge. It also shows that a corresponding structure need only perform the claimed functions, and you can't disqualify a structure for failing to perform unclaimed features. And I think some district courts have kind of drifted away from that requirement in recent years.
So I'll talk about the recent case Gesture Technology Partners, which was just decided in last December. The background is that Gesture Technology Partners is a non-practicing entity. They went on a litigation campaign, sued a bunch of tech companies. One of those companies was Samsung. And in the case against Samsung, the asserted claims were directed to a camera sensing movement. The claim was something like you put your finger in front of the lens and move it, and the camera can detect it. They also sued other companies, Apple and several others. In light of this campaign, Unified Patents brought an IPR challenging the patent that had been asserted against Samsung. The IPR was instituted. At the same time, Apple brought its own IPR challenging the asserted patent. That IPR was instituted. And Samsung did not pursue an IPR. Samsung requested ex parte re-examination of the patent, which the Patent Office granted. Both the Unified Patent and the Apple IPR were pending at the same time as Samsung's re-exam. The IPRs then reached final decision before the re-exam had concluded. And in the IPRs, all but 2 claims were invalidated. So there were still 2 live claims coming out of the IPRs. Meanwhile, Samsung's re-exam is still pending. In light of this, Gesture asked to terminate the re-examination and argued that the re-examination should be terminated because Samsung, as a member of Unified Patents, was stopped from raising grounds in the ex parte re-exam that Samsung could have raised in the Unified Patents IPR. And the PTAB said, no, that's just not how it works. The re-exam is owned once it is begun, it is owned by the Patent Office. It's not owned by the requesting party. And the Federal Circuit affirmed this. They clarified that even though a third party like Samsung in this instance requests a re-examination, it is the Patent Office that maintains it. And as a result, IPR estoppel under Section 315 does not apply. The other point that was affirmed by the Federal Circuit in this case is that the PTAB has jurisdiction to adjudicate expired patents. And the reasoning for this was that a patent owner's right to sue for past damages after expiration of a patent creates a live controversy such that the PTAB can review.
Okay, this last case is related to induced infringement, and it's set for argument before the Supreme Court next month. For background, a brand name drug manufacturer called Amarin sued a competitor called Hikma, who made a generic version of the same drug for infringement. Hikma had obtained what's called a skinny label, which excluded the patented use of the drug. So it got a label for some uses, other uses which were patented were excluded. After Hikma launched its generic drug, Amarin sued Hikma for induced infringement, alleging that Hikma's marketing and its label encouraged the generic product to be prescribed by doctors for the prohibited use not covered by the skinny label. The district court dismissed the claim, finding that there were insufficient allegations for intent to induce infringement of the product for the uses outside the skinny label. The Federal Circuit reversed. It emphasized that the label alone might not be enough in all cases to state a claim for induced infringement, but when combined with external communications that Hikma had made, so this is press releases and marketing statements, that suggested broad uses of the generic drug. So for example, they said that the drug was equivalent to Amarin's branded product. Those allegations can sufficiently allege the state of mind required for induced infringement. And notably, the Court of Appeal, the Federal Circuit observed that although this case has underlying features of a traditional Hatch-Waxman case, at bottom, it's nothing more than a run-of-the-mill induced infringement case. So HICMA has appealed the Federal Circuit's decision to the Supreme Court, which decided to take it up. On June 23rd, 2025, the Supreme Court invited the Solicitor General to file a brief expressing the views of the government on this issue, and argument is set for April 29th.
That's what we've got for you today. We'd be glad to take any questions that you've got about our presentation. If you have them, you can put them into the chat.